ma'am?
I didn't.
The misrepresentation, what was that?
My misrepresentation?
Yes. Put another way, what did you do and or say to receive these benefits that you shouldn't have done?
Oh.
Good afternoon, Your Honor. AAB Peterson on behalf of the people.
And Assistant Public Defender Jay Bonge on behalf of Ms. Hardy, who appears to my right. Ms. Hardy, can you please state your name for the record?
Tawana Jane Hardy.
All right, I have a plea form. Is that what we're doing on this?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to an added count to welfare fraud, $500 or less. Maximum penalty on that? That was the
I
question.
believe it's 90 days, I'm sorry.
It's 90 days, 90-day, $500 offense. There is, it's like $6,390.64 in restitution that would need to be paid on her successful plea to that charge. Count one would be dismissed. That's the court's full understanding of the agreement.
And it will also be pursuant to the late sentence statute, 771.1.
Okay, all right. She's pleading pursuant to the delayed sentence.
That is our understanding, Your Honor.
Whose case is this, Judge Barr? Okay, right hand. Solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes. State your name again, please.
Tawana Jane Hardy.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of welfare fraud, $500 or less. That is a misdemeanor punishable by up to 90 days and or a $500 fine plus court cost. Do you understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. All right. Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, has she signed any advice of rights form?
You know what, Your Honor? I'm so sorry. I'm not sure that she has.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for your trial or to have this court compel their attendance. You're giving up your right to seek, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record?
No, Your Honor.
Anybody threaten you or court?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
On free will. Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Between the dates of June 1st, 2018 and January 31st, 2019, did you receive benefits or welfare benefits from the state of Michigan?
Yes.
And in doing so, did you willfully make a false statement or representation to obtain those benefits or to obtain and or retain those benefits?
Yes.
All right. And what was that, ma'am?
I didn't.
The misrepresentation, what was that?
My misrepresentation?
Yes. Put another way, what did you do and or say to receive these benefits that you shouldn't have done
Oh,
or said?
that the child still lived in my presence.
And that was untrue
That was untrue
and a misrepresentation.
and
And
misrepresentation.
because of that misrepresentation, you received benefits.
Yes, Your Honor.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. The pre-sentence investigation and 1480 probation. Sentencing in this matter will be
May 22nd at 9 a.m. before Judge Barr.
May 22nd, 2024. What time?
9 a.m.
9 a.m. before Judge Barr. Bond will continue. Case People versus Deidre Woods. Excuse me.
Lori Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Woods. Your Honor, at this time, we'd like to, Ms. Woods does want me to address her bond to see if she can get a personal recognizance bond. There was a request. We made a request to see if we could resolve this with misdemeanors. At this time, we are not able to do that, and there are no offers. Ms. Woods is indicating that she wishes to waive the preliminary exam now then instead. Is that correct?
Yes.
And be bound over to circuit court. I can have her sign a waiver and so that we can do that. if we can.
Woods, is that correct? You're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes,
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
yes,
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on 4 counts with count 5 following. Ms. Gaines.
may I address you with a statement, something positive that I've done since you.
I'm sorry.
May I address you with something positive since the last time I was in front of you, Your Honor?
I think she wants to address bond, so
Okay, go
in
ahead.
terms of what you did positive, in terms of, you're talking about turning yourself in on the warrant.
Yes,
Yes, so we'll talk about that when we get to the bond.
okay.
Okay, all right. I didn't forget. Okay,
All right. So you're waiving formal reading and standing mute.
that is correct, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 17th at 1:30 before Judge Conlon.
April 17, 2024, 1:30 before Judge Conlon. Bond. Go ahead as the bond.
Your Honor, at this time, I'll start where Ms. Woods would like you to know. The last time, she says the last time she was before you, she did have an outstanding warrant from Wayne County
Yes.
where she had to go to the Mound facility, she stated. She says that that is all taken care of. At this time, she does have 2 other cases that are pending, but she has personal recognizance bonds in both of those. She has a permanent address in Ann Arbor that I believe was provided to the court at the arraignment. And she indicates that she can return to that address and she would return for all future court dates. She also did have a job. She's not sure, now that she's been in custody for a while, if she'll be able to return to that, but she would like to try to get that back. And your job was where again, ma'am?
That helping hands.
At Helping Hands.
Also, I have to report next week on the 10th in front of Judge Barr. So I was like for you to grant me a personal recognizance bond. I'm trying as hard as I can around there.
So that you have a bond on that case?
Yes, I'm on personal recognizance now for that case.
Yes, sir.
The one before Judge Barr.
Yes, sir.
All right.
That's correct. And the one, as I said, the one in front of Judge Valvo, I believe she has
It's
sentencing
at
today too
1:30.
for
Yes.
that. And there's a personal bond on that for her as well.
Okay. I'm proud of you, Ms. Gaines. That's the shortest bond argument you've ever given. Ms. Hughes.
Thank you, Your Honor. Your Honor, when my office charged this case, we requested 25,000 cash surety. I didn't do that request. When Ms. Woods' case initially came up on the docket, Mr. Ron Brown was assigned to this file. He called me for us to talk about this case, and I said, didn't we already handle her case? We just pled her to misdemeanors 2 weeks ago. Oh, no, that's because this is a brand new case. We were in front of Your Honor on March 14th, 2024, where she was charged with larceny and receiving stolen property. Her and a co-defendant went into an apartment complex, stole a TV. I pled that down to misdemeanors in front of Your Honor at the PCC on March 14th, 2024. At that time, the defendant requested a PR bond. I objected to the PR bond, citing that Wayne County hold that was showing for her for an assault out of Wayne County. The defendant convinced Your Honor that Wayne County wasn't going to come get her. It sounds like that turned out to be accurate. However, the defendant was then released on a PR bond. Statutorily, she is not eligible for another PR bond.
Correct.
So while she's out on a PR bond, she walks up to somebody who, my reading of the police report, is perhaps a perfect stranger to her, and she steals keys from him while he's working. The police arrive, they're flagged down by this victim, and she proceeds to assault 3 police officers, leaving one with a laceration to his hand. When that deputy brought her to the jail, he had to receive treatment to the laceration to his hand in the jail. She had been out on a PR bond for not 2 weeks by the time she already began engaging in this behavior, which is one of the many reasons that I am not agreeing to any type of misdemeanor resolution in this case, and why I'm reviewing our request for a 25,000 cash surety bond in this case. Thank you.
Anything else?
Um,
Well, I just want to be clear. The plea was taken, so she was out on bond on the other matter. What about the matter, that matter went to Judge Valvo or to Judge Barr?
I believe,
I mean, I'm trying to figure out, was she on bond? Clearly, she was on bond on one of the cases. Was she on bond on 2 cases when this arose?
All I know is when I saw you a couple weeks, Your Honor, I don't know, I have to go in front of Judge Barr for probation on the 17th. Also have to go in front of.
So were you on probation at the time of
No,
this?
sir.
So when did you get on probation?
I was supposed to leave a report and I did. They weren't treating me with dignity and respect. So I had walked out.
Your Honor,
to get-
she's scheduled for sentencing on both.
On which
I
one?
see Judge Bobo today for me not being able to report on time.
So on March 25th, she was actually on bond on 2 cases.
I believe so, yeah.
Motion for
Yes.
bond reduction denied, bond continued. All right, I've called the Payne matter.
Thank you, Judge. Good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P 85051, on behalf of Karen Payne. Ms. Payne, please state your full name for the record.
Karen Payne.
Have before me a plea form. Is that what we're doing today?
Yes, Judge.
All right. The plea form indicates that she will be pleading to operating while intoxicated, second offense, the 1-year offense. On her successful plea to that charge, the OWI third would be dismissed. That's the court's full understanding of the agreement.
That is correct, Judge. That is the defense understanding as well. Ms. Payne has been fully advised. She's prepared to be sworn and take the plea at this time.
Ms. Payne, can you raise your right hand to be sworn?
Yes,
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole
Yes.
truth, and nothing but the truth, so help you God?
yes.
All right, you can put your hand down. State your name again for the record, please.
Karen Payne.
All right. Ms. Payne, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor, punishable by up to 1 year in jail, 5 days to 1 year in jail. The court could also order community service and any rehabilitative programs the court deems necessary, and could order fines and cost up to $1,000. You understand that?
Yes,
The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
yes,
Understanding all of that, well, and understanding that you still wish to plead guilty to this offense?
yes,
I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
yes,
All right. Still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes,
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, man?
yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're indeed guilty of this offense?
yes,
Was that a yes, ma'am? I'm sorry.
yes,
All right. August 27th, 2020, at the location of Textile Road, Ypsilanti Township, Washington County, State of Michigan, were you operating a motor vehicle?
yes,
Prior to operating that motor vehicle, you consumed intoxicating liquor.
yes,
Do you recall what you had and how much?
no,
Judge, we would
All right.
stipulate it to blood alcohol level.
What was the blood alcohol level?
Judge, I do apologize. I would defer to the prosecution. I don't have the report in front of me, but I do know it was in excess of 0.09.
0.304.
0.3, 0.304. Yeah, that's in excess. All
And
right.
Judge,
And
not
ma'am,
to-
all right, you got stopped by the police, is that correct?
yes,
All right. And you were ultimately arrested.
yes,
All right. And you were taken to the hospital for a blood draw. Is that correct, ma'am?
yes,
All right. And if I told you that the result of that blood draw were 0.304, would you have any reason to dispute those blood test results?
no,
Had you previously been convicted on or about November 19, 2009 in the 34th District Court of operating while impaired or of operating while intoxicated on or about December 2nd, 2010, also in the 34th District Court?
yes,
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
May 16th at 10 a.m. before Judge Washington.
May 16, 2024, 10 a.m.
Yes.
10 a.m. before Judge Washington.
Thank
Bond
you.
with its conditions will continue. Thank you.
Thank you.
Thank you, Judge. Always a pleasure. Have a great day.
Thank you. This is Mr. Feaster's case.
It is, Your Honor. First Assistant Public Defender, please. In for Mr. Feaster.
Sir, can you please state your name?
Nathan K. Estep, Your Honor.
Thank you, sir. What are we doing?
Your Honor, I'm unsure if Mr. Estep spoken with Mr. Feaster.
Have you talked to Mr. Feaster?
Not yet today, Your Honor.
Okay.
Not, I'm sorry?
He said no.
No.
Then we'll need an adjournment, Your Honor.
That is correct, Judge. George Hill Feaster, Assistant Public Defender on behalf of Mr. Estep. He's going to be entering the drug court in Livingston County, and we're going to try and figure out a resolution.
Okay, so he's going into the drug court there.
Yes, Judge.
And you're trying to figure out some way to deal with this with that.
Correct.
Got it. How much time will that take you to?
I gotta get proof that he's in the program there, so maybe 2 or 3 weeks.
Okay. Are you in the drug court program yet, sir? Or?
Yes, Your Honor, I'm accepted in and everything. I'm supposed to be starting when I get out of here. My out date here is Monday, but I have this going on as well, so I have a bond over there. I don't know. I don't know exactly what's going on with that, but yes, I am accepted in and I'm supposed to be starting it.
So my goal is to get proof, tender that to Mr. Ganatra, and see if that might help the
That might help okay, gotcha. So you want 2 weeks out?
Please.
Probable cause adjourned April 18th, 2024, 9 a.m. as your invite indicates. Bond will continue. All right, sir. All right, thank you.
Thank you, Your Honor.
I've got one very big one left from that last block. I realize we're supposed to start the 1 o'clock. I'm going to take a very brief break. I want to check on something and then I'll come back. I'll start calling the 1 o'clock cases. Sorry about that, folks. Court's in standing recess. Court recalls the case of the People versus Scales.
Assistant Public Defender Jay Bellinger on behalf of Ms. Hughes again. I'm sorry, Ms. Scales again, who approaches. Ms. Scales, can you state your name for the record?
Carla Chandel Scales.
Okay, so we had an exceedingly lengthy bench conference about this case, and before going into all of those details, the court was looking at some other things, and I'm awaiting additional information that I will pass along to counsel once I receive it. I'm going to try to get some of these people out so they can have dinner too. So what I'm going to do at this point is I'm going to pass the matter, but fundamentally, given what I've determined, the defendant is going to be taken into custody at this point. We'll hold her. I will call it back up around 3 o'clock.
Okay.
Can counsel, so defendant is remanded at this time. So ma'am, you'll have to go with the bailiff. Counsel, can you approach?
Yes, Your Honor.
Our calls case, People versus Christopher Decker.
And children's agreeing on behalf of the people.
To my right at the podium, please state your name for the record, sir.
Christopher Decker.
Thank you.
Welcome, Your Honor.
Thank you, Judge. I met with Mr. Decker and I've spoken to the people. Mr. Decker is requesting as soon as possible preliminary examination. I believe he wants me to address bond.
Pardon?
I believe he wants me to address bond.
All right. Discovery is complete.
Yes, understand.
And would the people have their witnesses available the 16th? Preliminary examination in this matter in person will be set April 16th, 2024, 9 a.m. That is before Judge Falvo.
Thank you, Judge.
As to bound.
Thank you, Judge. In meeting with Mr. Decker earlier this week, he indicated that he had a residence here in Washtenaw County, and that residence, the people living with him are going to be evicted as of this coming Monday. He indicates he has property in that residence he needs to remove so that it's not trashed. He's asking Your Honor to consider some type of police. He can have no contact with the alleged victim in this case. He can use a police standby if for any reason she might be at that residence. But he is hoping to be able to save those belongings removed due to eviction.
Other than that, no.
Okay. That's all.
GPS tether is also about. Another judge.
Okay. And apparently he has another case where he is on GPS tether if he is ever released. What judge is that in front of?
It was Van Buren. I think her name is Van something.
Oh, Vandenberg.
Vandenberg.
Sorry. There's a PPO file, I'm sorry, Judge, that is companion to this with the same victim. Judge Vandenberg has put a condition of his release that he be on a GPS tether if he's released on that on this file.
So who's the PPO regarding?
The same domestic violence victim in this case.
That was in place before this arose?
It's part.
It arose around the same time.
Yeah,
The PPO was served on the defendant approximately 6 days before this.
Okay.
Thank you.
Anything else?
No, nothing else, Judge.
There's nothing else? I don't need a response. Motion for bond reduction denied.
Thank you, Judge. All right, see you at court. Thank you, Judge.
You're welcome. Court calls case People versus Thomas Belcher.
Assistant Public Defender Jeff Bellinger on behalf of Mr. Belcher, who appears by my side. Can you please state your name for the record?
Thomas Belcher. Thank you. What are we doing?
Your Honor, we are here on a competency this morning. I was just made aware that I am in receipt of that file. I'd like an opportunity to go over that with my client. However, we're asking for 1 week.
So a few things, Your Honor. As far as the competency report, we did just get that in. My understanding is Belcher has been found competent. I was stipulated to that report. Second part of it is there are some issues we need to discuss regarding jail calls that were made. But to begin with the competency report, I did forward that to PD Bellinger about half an hour ago. So no objection to an adjournment for that.
Got it.
We also discussed, I did share with PD Bellinger some of the information regarding the calls. I don't have all of it. So him and I would obviously need to discuss that further. They are concerning, there are calls to the minor victim's mother regarding this case. It goes as far as, despite her saying she cannot legally speak to him, Mr. Belcher decides then to continue to try to influence her by mentioning how this is ruining her life, how she should be charged as a co-defendant, so on and so forth. I'll spare the court the rest of it for now, unless you have specific questions. They are concerning enough. I spoke to Mr. Bellinger this morning about, it sounds like we may need a hearing. We may want to adjourn it. Of course, I'm sure he would like an opportunity to hear that audio, and so on. So that's where we are.
Okay, just try to get clear. I have 2 protected parties in terms of no contact. Are those minors that are?
Yes, the victims are minors. Your Honor, could we approach?
Yes, please. Record should reflect we've got a conference in this case. What I'm going to do is I will adjourn the competency hearing, although part of the people have stipulated to the report, defendant needs to go through that with counsel, and we'll go out 1 week. Also, there is potentially going to be a stipulation regarding an added protected party to the bond condition, so I will also await that. So it'll be adjourned to April 11th, 2024, 9 a.m.
Thank you, Your Honor.
Court does call the cases the People versus Tracy Benson.
Joe Feaster, Assistant Public Defender, on behalf of who should be appearing from the Forensic Center by Zoom.
They would be, except there was no writ done, so they're not going to be appearing today.
Okay.
So I will adjourn the probable cause conference to the 25th. Pardon? Oh, the prosecutor's in Zoom. I'm sorry. Want to state your appearance, sir?
I will. Good morning, Your Honor. Isaac Sneed on behalf of the people.
Okay, I didn't mean to leave you out. All right. There was no writ done, so I was going to adjourn this to April 25th.
Understood. Thank you.
24 at 9 a.m.
Out of curiosity, Judge, do you have an updated competency report?
Do I have an updated report? I have not. The last report I have is from September. I do not have an updated one.
All right. Thank you, Judge.
So hopefully we will. This was set for competency hearing, eh?
Yeah.
I believe it's set for competency. So I'll go the 25th. Let's see what happens.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Bond continue. Court calls case People versus Jadan Merida.
National Senior Assistant Prosecutor.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P85051, on behalf of Jaden Merida, who is in custody, Judge.
Yes. Mr. Merida, can you state your name? Jaden, good morning, Your Honor. All right, what are we doing?
Judge, this is my first appearance on this particular matter. I'm humbly asking for an adjournment, 3 to 4 weeks. Give me time to get up to speed and to obtain discovery in this matter, Judge.
Is this the only thing holding you?
No, I got a probation remand.
I gotcha. All right. Probable cause conference then will be adjourned to April 25th, 2024, 9 a.m. Bond continued.
Thank you, Judge. I also have one other matter, Karen Payne, if Your Honor.
Pardon?
I also have one other matter before this court, Karen Payne. If Your
So
Honor
what do you
would be so inclined.
in front of me? And that's not how I do it. You know that's not how I do it.
My
So
apologies,
sit-
Judge.
Hey, or you can come down here. Which would you prefer?
No, Judge, thank you for your accommodations, Judge.
Yeah, you're welcome. Court calls the case, People versus Marcus Williams.
First Assistant Public Defender Quinn Anderson on behalf of Mr. Williams. Mr. Williams, state your name, please.
Marcus Williams. Thank you.
Your Honor, we're going to set this for a preliminary exam, and at the appropriate time, I'd ask to address his bond. Put that away,
But he's out.
and we want to keep it that way.
Yeah, okay. You have all discovery?
Yes, Your Honor, thank you.
Would the witnesses be available the 16th? Preliminary examination in person will be set April 16th, 2024, 9 a.m. before Judge Fresh Hour. Yes, Ms. Anderson as to bond.
You ready?
Sure. Hey, I'm good. I'm ready to roll, always.
Your Honor, he's currently on a hot zone tether. He presents to the court with no prior convictions on his record. This is financial hardship, obviously, but I've not received anything indicating that he has violated the tether conditions or any of his bond conditions since the arraignment. He's asking the court to consider removing him from the tether and just keeping the no contact, no go to in place.
I don't need a response. I'm not going to do that. I've got two. I understand the presumption of innocence, but I have 2 DV charges on this, and his tether is an exclusion. So there's the only other way that I could assure his exclusion from that area would be to incarcerate him, and I don't think you want that alternative.
No, thank you, Your Honor.
All right. Bond will continue.
All right, thank you.
You're welcome. Court calls case People versus Cortez Weston Hinton.
First Assistant Public Defender Quinn Anderson on behalf of Mr. Weston Hinton. Please state your name.
Cortez Weston Hinton. No, how are you?
Your Honor, this will be a waiver. We're going to seek HIDA in the circuit court.
Sir, is that correct that you're waiving your right to a preliminary examination?
Yes, sir.
All right, you understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
That's right.
Preliminary examination having been waived, defendants bound over on a single count. Ms. Anderson.
Thank you, Your Honor. We received a copy of the information. Waiver's formal reading, stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
May 13th at 1:30 before Judge Slay Monday.
May 13th, 2024, 1:30, Slay Monday.
What you got in your hands? That's something for me?
Bond in this matter will continue. Thank you, sir.
Your Honor, he does have his completed fingerprint order. Should he just take that to the front counter?
Court calls the cases of the People versus Beverly Tuttle.
Mr. Camacho, Senior Assistant Prosecutor.
On behalf of Ms. Tuttle. Your Honor, Ms. Tuttle called our office earlier today and informed us that she was not able to secure transportation for her hearings today. And she also advised us that she's looking to obtain a private attorney.
She couldn't obtain transportation.
Well, and maybe if she's saving for the private attorney, she's not able to Uber.
She couldn't obtain transportation from Ann Arbor.
That's my information. That is my information.
From Ann Arbor.
The Uber fees are going.
Bus stop right out there. Is that all you got?
That's my
That's
information.
it, okay. Bench warrant. Bond. Bench warrant will issue both of these matters. Bond set at 10,000 cash or surety. Those warrants will issue immediately. Thank you. Court calls the case of the People versus Cecil Bates.
Alex Warren Green on behalf of Mr. Bates, Your Honor. Received an unfortunate email from the Kalamazoo County Medical Examiner. Indicates my client is no longer with us. I did provide that to Ms. Hughes, and I believe they're looking into what they need to do on their end. So we'd ask for a brief adjournment.
Probable cause conference, I'll adjourn it to the 18th. Get all the paperwork.
And Your Honor, I can provide that to the court as well.
Pardon?
I can provide the correspondence.
The correspondence, okay, but I think got it. Court calls case People versus Sylvester Alexander. Did we get all of the ones they wanted?
Andrew Childress, attorney on behalf of the people.
Edward Drukas on behalf of Sylvester Alexander. I'm standing in for the attorney record, Bob Kellewald.
Your name, sir?
Sylvester Alexander.
You have any objection to Mr. Drukas standing in? All right, go ahead.
Your Honor, I did speak with Mr. Kellewald. He has gone over the discovery. I believe they do have everything. So they're looking for a preliminary examination.
People have their witnesses available the 16th.
I'd ask for anything other than the 16th, Your Honor. He is in I think there's a murder trial that he has that week. So he'd be asking for the 23rd. I did bring that to the attention of the prosecutor.
23rd. All right. Preliminary examination in person, April 23rd, 2024, 9 a.m. That is before me. Calls the case People versus Jerry Bigham.
Sorry, Your Honor, I missed the name. Andrew Van, Assistant Public Defender, with and on behalf of Mr. Bigham, who's present, and who is requesting. Mr. Bigham is requesting a preliminary exam in this case, Your Honor.
Discovery complete?
I believe it is, yes.
People have their witnesses available the 16th. Preliminary examination will be set in person, April 16th, 2024, 9 a.m. before Judge Valvo. Bond will continue. Court does call the case People versus Jacob Dupuis.
Andrew Van, Assistant Public Defender, with Mr. Dupuis, present. Your Honor, in this case, I'm respectfully requesting an exam, if possible, in 4 to 5 weeks. Simply, that relates to my client's new employment. 4 to 5 weeks work well with him, if it is okay with the court and the people.
I have no objections.
Discovery is complete.
Yes.
And the witnesses. Preliminary examination in person, May 7th, 2024, 9 a.m. That's before Judge Freshour.
Thank you, Your Honor.
With your honor. Bond will continue. Thank you. Case People versus Joseph Taylor.
Edward Drukas on behalf of Joseph Taylor. Your Honor. Your Honor, I was appointed this morning. Ultimately, I need the discovery in this case. So for purposes of today's hearing on the probable cause conference, I'm asking for an adjournment. And I understand that we would like to address bond as well today.
Pardon?
We would like to also address bond.
So you need an adjournment of these proceedings?
Yes, Your Honor.
April 18th, 2024, 9 a.m. Yes, as to bond.
Your Honor, as to bond, information that I received is that he does have stable housing. If he were to get out, he'd be living with his fiance. He is currently looking for employment.
His fiance, the one that's the victim, alleged victim of domestic violence. So there's a domestic violence and a fiance. Okay, go ahead.
So from what he tells me, he would show up at the next court appearance, Your Honor, and he'd work with me regarding going over the discovery. And he wouldn't have any contact with the complaining witness.
Response.
Hey, counsel approach.
Sure. Record should reflect we had a bench conference in this case. At this time, the court's going to deny any request for bond reduction. Bond will continue as is.
Okay, thank you, Your Honor.
Cross case People versus Mohammed Farah.
Good morning, Your Honor. First Assistant Public Defender Queen Anderson.
Oh, I didn't know you were in the room. That's why it felt so joyous.
I see your smile is bigger now, Judge. It's okay. Your Honor, I've not had any contact with Mr. Farhar. I'm happy that he appeared today. I was afraid you were going to pull out some stickers on me, but he's here. I would just ask for an adjournment so we can speak.
Have you not been in contact with his attorney, or what's the problem?
I was not assigned an attorney yet.
Oh, you certainly were.
Probably, yes.
Yeah, and I called you several times.
Okay, I'm sorry. I'll give you a phone number.
Okay, he's going to give me a good number, Your Honor, and we're going to get in contact before the next PCC.
Otherwise, I'll have to put them in a place they can find you. Understood?
Yes, Your Honor.
Probable cause conference, April 18th, 2024, 9 a.m. Bond continue.
Thank you, Your Honor.
Court does call the case of the People versus Deja Foster.
We are already in this matter, Your Honor.
Senior Assistant Prosecuting Attorney for the People.
Lauren Brown, Deputy Chief Public Defender, being with and on behalf of Ms. Foster. For the record.
Thank you.
Your Honor, today is the date and time set for a competency I received a letter from forensics indicating only recently interviewed her, March 21st, I think was. They still need time to complete the right up there.
I will then adjourn this hearing to, well, we just go May 2nd. We'll move it up if necessary. May 2nd, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus David Floyd.
Morning, Your Honor. Edward Jurgis on behalf of David Floyd.
David Floyd. Thank you.
And Your Honor, I am in receipt of all the discovery to my knowledge, and we are asking for a preliminary.
People have their witnesses available the 16th. Preliminary examination will be set in person, April 16th, 2024, 9 a.m. before Judge Feshauer. Bond on this matter will continue. Thank you. Court calls case People versus Aaron Bowers.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Bowers.
Mr. Bowers, can you state your name, please?
Aaron Joseph Bowers, Your Honor.
Thank you.
Your Honor, we are requesting one more adjournment. I believe we're close to a resolution. There are just a couple of questions we have as far as restitution.
He was in Kentucky, right?
That is correct.
He's not there anymore.
No, he is not.
Okay, just checking. So you need another adjournment.
Yes, please. Just a week or two, please.
How much more time did you need?
Just a week or two, please.
Just a week or two? Probable cause conference, April 18th, 2024, 9 a.m. Bond will continue. Thank you.
Thank you.
Your Honor.
Court calls the case People versus Jaquavius Carroll.
Courthouse Violations, Assistant Public Defender on behalf of Mr. Carroll.
I didn't know you were in the room.
I'm hiding, Judge, over in the corner.
Did you tell Mr. Martell to do that?
I did not, Judge.
You,
No,
okay.
I had
just
no role,
checking.
no part in that.
I think you were trying to tell him. Go ahead.
I was trying to text him, tell him not, don't say anything, don't do it.
Okay.
I've met with Mr. Carroll and I've spoken to the people, Your Honor. My understanding is we're tracking a federal matter. If we could adjourn this for, I think, 2 or 3 weeks to find out what's happening.
What's happening with that one? Probable cause conference will be adjourned April 25th, 24, 9 a.m. Bond in this matter will continue. Thank you.
Judge.
Court calls the case People versus Dennis Thick.
Andrew Bannis, Assistant Public Defender, with on behalf of Mr. Dick.
Good morning, Your Honor. Dennis Thick.
Thank you. What are we doing?
I'm asking for an adjournment. We are very close, I think, to resolving this case.
Probable cause conference, April 18th, 2024, 9 a.m. Bond continue.
April 18th, come back.
Yeah, yes, sir. Thank you.
Thank you, Judge.
Court calls the case People versus Raymond Tubbs.
Ready to commercial officer, Assistant Public Defender on behalf of Mr. Raymond Tubbs. State your name for the record.
Raymond. Inside or off, either way. All right, thank you. Mr. Feaster knows with a bald head, it's easier to slide over. Go ahead. No, it's okay. You're all right.
I've spoken to Mr. Tubbs and to Mr. Ganache on this file. We're working on getting it resolved. Not quite there yet. If we could have a week or two, please.
Probable cause conference, April 25th, 2024, 9 a.m. Bond continue.
Call me. You got my number. I'll give you the. Thank you very much.
Thank you. Court calls case People versus Kenya Weatherspoon. Thank you.
Attorney Feaster, Assistant Public Defender on behalf of Mr. Weatherspoon. And for the record.
Kenya Weatherspoon.
Thank you.
Thank you, Judge. This is my first time meeting Ms. Weatherspoon. I believe our first pretrial on this file. My understanding is we need to have some serious conversation. This is a serious case, so we're gonna take some time to try and get this figured out. If we could go out 3 or 4 weeks, please, Judge.
Without objection, April 25th, 2024, 9 a.m. Bond continued.
Thank you, Judge.
Court calls the case People versus Lori Williams.
Joy Gaines, Senior Assistant Public Defender, representing Ms. Williams. Your Honor, Ms. Williams is working with our mitigation team, and we are asking for some additional time, maybe 3 weeks. So
To
that
do
they,
the letter, 3 weeks to do a letter. Without objection, probable cause conference, May 2nd, 2024, 9 a.m. Bond continued.
thank you.
Court calls the case People versus Jada Olive.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Olive, who is present.
Yeah, but Mr. Cash is withdrawn.
He's here.
I know, I saw him running around, but he's not here right now. What are we doing? You're going to be requesting an adjournment. And
Correct, Your Honor.
let him withdraw. I'll grant his motion. Probable cause conference will be adjourned 25th,
Thank you, Your Honor.
2024, 9 a.m. All right, bond continued.
Your Honor.
Thank you. Court calls the case of the People versus Alan Norris.
On behalf of the people.
Good afternoon, Your Honor. Dave Coleman, appearing for today's hearing only on behalf of Mr. Haney, who could not be here today. Mr. Morris is here.
Okay, and you have no objection to?
I have no objection.
All right, very good. All right, what are we doing?
I was emailing back and forth with Mr. Haney. Ms. Barroso had been handling this case, although she had made me aware of some things going on. We're looking to adjourn this just one last time in hopes it can be resolved.
All right, how much time do we need?
I don't know Mr. Haney's schedule, but
I don't either. No.
perhaps.
Why don't we do, shall I do the 25th and then see?
That would be fine.
All right, probable cause conference, April 25th, 2024, 9 a.m. bond continued. Thank you, sir.
Thank you, Judge.
Thank you. Court calls case People versus Christopher Duffy. Good morning.
Ron Brown appearing on behalf of Commissioner Canales, Senior Assistant Counsel. Your Honor, tell me your name.
Christopher Duffy. Nice head of tire. Go ahead.
We're requesting adjournment, Your Honor.
April 25th, 2024, 9 a.m. Bond continued. Didn't get him time to get his hair done, so he doesn't wear that back in here. Thank you. Court calls case People versus Michael Erickson.
Andrew Childers, on behalf of the people.
Alex Warren Green on behalf of Mr. Erickson. Provided the court a paper copy of the preliminary examination waiver. Mr. Erickson does wish to waive his right to a preliminary examination today.
Is that correct, Mr. Erickson?
Yes, it is.
You understand, whose phone was that? You were wrong. You understand that a preliminary examination is the proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
I do understand that, yes.
And you understand you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Acknowledge receipt of the information, waive its reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 18th at 1:30 before Judge Slade Thursday.
April 18, 2024, 1:30, Slade Thursday. Thank you. Bond continues.